Hello, folks. My name is Sam Van Kopp. I'm the chair of the Washington, D.C. chapter of Principles First. If there's any folks in the audience in the DMV area who'd like to be more involved in Principles First, please just find any volunteer in the room next door. We'll make sure to send you an email. Our next panel features three eminent retired judges speaking about the rule of law, a 250-year staple of American greatness. The Honorable Maureen O'Connor was the 10th Chief Justice of the Ohio Supreme Court from 2011 until 2022. She also served as president of the National Conference of Chief Justices, where she championed reform of state judicial systems. The Honorable Thomas Griffith presided at the U.S. Court of Appeals for the District of Columbia between 2005 and 2020. Before that, he was a partner at Wiley Ryan and was named legal counsel for the U.S. Senate. Judge Alexander Williams was appointed to the U.S. District Court for the District of Maryland by President Bill Clinton, and he served there from 1994 until 2014. Judge Williams previously served as state's attorney for Prince George's County, Maryland. Our moderator is Brenna Trout-Frey, an attorney who left her global law firm in 2025 after it settled with the Trump administration to avoid becoming the target of an unlawful executive order.
Thank you, and I'm really excited to be here today with our esteemed panel of judges. I think this weekend is a particularly timely moment to have this discussion on the rule of law and the role of the judiciary, especially after the Supreme Court's decision on Friday, so I'm hoping we can get into that. I want to start with an opening framing question, and maybe, Judge Griffith, I'll go to you since you're right next to me. As we mark 250 years of the American experiment, what does the rule of law actually mean besides a slogan, and why is it so central to who we are as a republic?
Well, the rule of law is a fragile possibility, and it teaches us that when we, the people, gather together and decide upon the rules by which we'll live, that it's binding on everyone. And that we will live by those rules that have been decided ahead of time, that we will not bend those rules for political expedience or because they provide onerous process or because they get in the way of what we want done. No, we will follow the rules by which we have established society. We can change those rules, but the way we do that is through the complicated and onerous lawmaking process set forth in the United States Constitution. So the rule of law, in my mind, it's simply following what the Constitution has already laid down in terms of what the processes are that you follow to create law and what the substance of those is.
And I think, we've seen recently some attacks on the judiciary and its independence. And what are the guardrails? Maybe I'll ask you, Chief Justice O'Connor, what are the guardrails that protect judicial independence in the United States? And where in this moment are they strongest and where are they most vulnerable?
Well, thank you for the question and thank you for the invitation to be here. The guardrails that protect the judiciary in the federal system, your lifetime appointment and the fact that your salary cannot be interfered with is certainly an important guardrail. For those of us that have been in state government, we have the same guardrails as far as your income, your salary, not to be tampered with by the legislature or the executive branch. But besides those practical guardrails, the independence of the judiciary is the mark of the judiciary. It is the identification of the judiciary. It is only as good as the people's belief and trust in the judiciary. And that's why it is so important for judges to be transparent in their workings, not their deliberations, I'm not advocating for that, but through their work product, through their opinions, to be very clear, to be very consistent, to offer rationale that is understandable, not only to the lawyers, but understandable to the people of this country, those who are interested. It's important to educate the people on the role of the judiciary, which is one of the most misunderstood branches of government, to emphasize that there is no constituency but for the rule of law, that there is no politics involved in the judiciary. I always say, and I come from a state where the judges are elected. I ran statewide to be on the court to begin with and then to be Chief Justice. But I say, if you bring your interest with you when you have your robe on at the bench, you don't deserve to wear that robe if that's how you are operating. Especially if one of those interests are the politics, and you're worried about the politics of the decision. How is it going to affect your party or another party, et cetera? A court has to be used uniformly. It can't be used to punish. It can't be used to get back. It can't be used to curry favor. The court is a singular institution that is, as I said, guided by nothing but the rule of law and actually the integrity of the individuals who occupy those seats. And that's why it is so important that we educate our citizens starting in grade school and enhancing what we teach in our schools to the children about the operation of our government.
I agree with everything Maureen said. Can I add one thing? In my perspective, what's the greatest threat to judicial independence today? In my view, it's the views of politicians and people in the public who think that what's really going on in the courts is just politics. It's just politics. I can tell you from my experience on the federal courts, my experience on the D.C. Circuit. In 15 years on the D.C. Circuit, I only once saw a decision that I thought was in any way tainted by someone's partisan priors, and that was a mistake. That was a mistake. But in the hundreds of other cases, no politics, just following law. So now, when politicians and public intellectuals say that what's going on at the Supreme Court is you're either trying to help Trump or impede Trump, you're missing the story. That's not what's going on there. These are tough issues that they're wrestling with legal principles. And we're free to disagree with them, but I don't want anyone in this room to think, well, you can think what you want, but I'll tell you what I think. I know these people. These are 9 people who are acting in good faith. You may disagree with the result, but they're not doing politics. They're doing law. And they're doing law on tough issues. And when politicians and public intellectuals and advocacy groups accuse them of being partisans in robes, A, that's inaccurate. B, it undermines confidence in a judiciary that isn't perfect by any stretch of the imagination, but is in many ways the crown jewel of our American democracy. And when we undermine faith in the judiciary by saying they're just being partisans, we're doing lasting damage. That's body blows to the confidence that the American people deserve to have in the judiciary and the Constitution.
And I certainly agree with that. I think the biggest threat to judicial independence would be twofold. One is the constant assaults and attacks and threats on judges, threatening to impeach them, threatening that they're impartial, that they're fair, unfair, and so forth. So that's one threat, just the threats and the comments and the description of judges as being crooks and that sort of thing. And the second issue for me that's a threat to the independence of the judiciary is, I call it the gunfire and assaults on judges. And what's happening is a lot of judges being threatened and shot at and other kinds of things, and that's a problem for me. So judicial security is a real issue that has to be addressed by Congress and the people. We've got to protect our judges from these type of threats that's taking place.
I'd like to add, just in closing on this topic, and I'm sure we're going to move on after this, but the labeling of judges by the media does a disservice to all of us, especially the judiciary. when you see an article that involves a federal judge, district, appellate, or Supreme Court, the president that appointed them is always mentioned, within 2 words of the name of the judge or justice. And as Chief Justice Roberts said, there's no Obama judges, there's no, Clinton judges, et cetera, and that's absolutely true. And in, my case in Ohio and other states, they will label your individual party representation. I was a registered Republican, and so I was always the Republican Chief Justice, Maureen O'Connor, which in the end, the Republican Party disowned me. They turned my picture at the headquarters. They took it down at the party headquarters, and then some of the county offices turned my picture to the wall. They didn't like my opinions on redistricting, and they were going to impeach me in the legislature. So everything that we've talked about the threats, I endured my last year in office. Not that it bothered me, believe me. But my point is that affiliation with a party does a disservice to the entire judiciary. And if there are members of the media here, please never, ever say that again about a judge. It does a disservice.
Sure, and why do we have to read every time there's a case, so-and-so was appointed by this president or what have you? What difference does it make? We're judges, and we're trying to do the best job that we can under very difficult circumstances. So I just disagree with the media putting a label
I agree, yeah.
on a party affiliation.
Yeah. So I think that gets into the need or the requirement for the judiciary to follow process and precedent. And you're saying that's really what you go by. You're not going by your political affiliation or your desired outcome for the case. You're really following process and precedent. Can one of you speak to why that's so important, why that is so ingrained in our idea of liberty in our country, that judges follow process and precedent, and why that protects us and the rule of law?
My appellate judges start.
Okay, let me take a stab at it. So let's go back to 1787. We're in Philadelphia, and we're creating a new form of government. There are lots of different models that they could have chosen off the shelf. They could have done, they obviously didn't like a monarchy, but they could have gone to a theocracy. They could have gone to an aristocracy. They could have gone to Plato's wise men. They could have done a lot of different things, but they didn't. They chose a system of government in which we, the people, make the rules by which society is run. And that we, the people, do that through democratically elected representatives, people who are accountable to the we, the people, in elections. If you go back to when I was in high school and had civics, there was a cartoon called How a Bill Becomes a Law. It's now in Schoolhouse Rock, right? I'm just a bill on Capitol Hill. Think about that intricate process by which we decide the rules by which society governs. There isn't a judge in that song. There isn't a judge in that picture. We don't want unelected, life-tenured judges who are not politically accountable to be making the rules by which we govern society. That's up to the elected representatives of we the people. And judges, when we're doing our job right, are nothing more than agents of we the people. We're saying, we the people decided this is the value that governs here. I may disagree with that value, but I'm going to apply it. Now, I'm the hero of all my own stories. I will tell you, I was on the court that decided the case that became Heller, that went up to the Supreme Court and recognized the right of an individual under the Second Amendment to defend himself or herself with a weapon, okay? Okay. Now, personally, I'm a gun control guy. If I was an elected representative, I would be in favor of the strongest. If we had a constitutional convention, I would vote to repeal the Second Amendment. I know it's going to upset some of you. I don't like it. I don't like it. So what? That has nothing to do with my job as a judge. My job as a judge is just figure out what were the framers doing with that Second Amendment? And whether you like it or not, they really believed that an individual has a right to have a weapon to protect himself. I don't like that, but that's in the Constitution. That's what a judge does. As Justice Scalia said, if you're a judge and you agree with all your own decisions, you're a bad judge.
And that's the beauty of the rule of law, the separation of powers, the respect for equal branches of the government. That's all what it's about, accountability and impartiality, openness, transparency, and respect, not just for other branches, but also for the states, that they work together in tandem to deal with that. And we get to the point that it's about ourselves, then we're just missing the point, and that's not what the rule of law is all about. The rule of law is a code, a collection of values that the people have had and respected for years, and it's the glue that holds our society together, the rule of law. And it's all of that which you've heard on this stage here today.
And I also think that when we're talking about precedent and we're talking about the respect of precedent and the usefulness of courts relying on precedent, it's not just useful for the courts, because then those decisions that come out of the court are interpretations, applications of the law. And what does that do? That allows for consistency in the rule of law. It allows for people to be able to, when I say people, I mean corporations, I mean contracts, I mean, individuals, etc. You know what the law is, and you know how it's been applied, so you know what the parameters are in this situation, or how to write this contract, or what to include. And if you're a legislator, you look at what the precedent is and how the courts have ruled on something, and if necessary, you introduce amendments or laws that will effectively change how the interpretation, if you don't like the way the court ruled, you can change the law. And that's what we always used to say, to each other in conference. Hey, if they don't like what we just did, they can change the law, but this is what the law says now. And the legislature can react to courts, and they do react to courts. And that's part of the process, that's part of the public process. And guess what? People get to weigh in with the legislature and testify whether they like the change in the law or what direction, et cetera. So again, that's a people-involved process as well, where the deliberations of the court are not influenced by the people. But the laws that we have are public, they're prospective, and they are stable when the court includes them or rules on them in their case. But it is the job of the court to be crystal clear in what they write and how they've arrived at their decision, and make sure that the breadcrumbs are all there so that people can follow them to get to the resolution that is in the majority opinion. That's some of the opinions that are drafted. I think it's really wrong for a judge to immortalize themselves in an opinion, but too often that happens. Judges are human.
If you want, in my view, if you want a really great description of what the other members of the panel have been saying about the role of a judge, it's out there right now. It's in Justice Barrett's book, Listening to Law. It's a great book. It's a great read. You don't have to read the whole book to get what I'm getting at. Chapters 2 and 3 of that book are, in my estimation, the best description I have ever read about what a judge does. Chapter 2, she talks about the oath. Every judge takes an oath to be impartial, and we take that seriously. Chapter 3, she talks about collegiality on an appellate court. You go get that book. It's a great book. You read chapters 2 and 3, and you'll have a better understanding of what the judiciary is about in America and what it's supposed to be. And then you can tell your friends who are critical of courts and their decisions to read the same thing so that they can have a better understanding of what's going on. It's not partisan politics. It's about following an oath. It's about following the law. It's about collegiality with your colleagues. I don't get any money from that. Okay, that's just it's a great book.
But he can get the book autographed for you.
I'm curious what you believe the judiciary's responsibility is to respond when it is attacked and its legitimacy is attacked by the public, by the president, by anyone out there. And I think we're in a moment right now where the president has been very vocal with decisions or judges that he doesn't like. What is the judge's responsibility in that moment? Is it to, keep calm and carry on, not respond other than within the opinion? Or does the judiciary have some responsibility outside of the case to protect itself?
Let me say that judges occasionally, they teach law at law schools. They have a chance to impress something to the students. They also get invited to various conferences and community organizations that they can talk. They certainly can write opinions. And there is an opportunity for judges to turn this thing around. I think it's about educating people about what's going on. Judges have an ethical code not to speak out, particularly on their cases and cases in general, but they do have an opportunity to educate people. And the other thing I would say is judges have to fight back. I was part of a court in the United States District Court for the District of Maryland where the government sued the entire court, active judges as well as the senior judges, because they didn't like the rulings of Maryland. But the judges fought back. They hired counsel, and they ended up getting favorable decisions by the Supreme Court from that standpoint. So sometimes we have to fight to protect our independence.
I think that traditionally it fell upon the responsibility to speak out for the judges fell upon the bar associations, the members of the bar. They were charged with being the protectorate of the independence of the judiciary by the lawyers speaking out and judges remaining silent. And just recently there was a change in that, at least for the federal judges, that under limited circumstances there's guidance on when they can speak out now. So they've kind of, I don't want to say have taken the muzzle off, but loosened the ties, for the federal judiciary. But I would be remiss if I didn't let you know about the organizations that have formed in recent times, and I mean very recent times, like this year and last, to speak out and protect the judiciary. The ABA put together a task force for American democracy. That task force is now a separate entity, a 501c3, but what they do, and they do quite well, is have probably at least twice a month Zooms that educate on the independence of the judiciary, talk about, what's happening. They're very, very influential. In my own experience, there's a group called Ohioans for the Rule of Law, which has just been initiated. It's lawyers and judges coming together to educate the public and to draw attention to the rule of law and its prominence in our society. There's another group called the Alliance of Former Chief Justices, which I'm on the executive committee. That was just formed this year. And we are there, we're kind of affiliated with the Keep Our Republic organization, and that our role is if a judge, a state court judge, is criticized, that we will come to their defense as a group and individual op-eds, that sort of thing. I've done one with a colleague from the Supreme Court in Ohio, in the local newspaper in Cleveland. So there is a lot of activity, and this is what I'm just described is just a microcosm of what is out there. I mean, you look at the groups that are represented out, in the lobby here. There is activity, there is action like I have not seen before to protect not only our judiciary, but to protect the other institutions of our government, because we are nothing without our institutions and the stability of our institutions. And what we see is, is intentionally destabilizing, our institutions. And they need the protection. They need the protection of the public. They need the protection of the professionals. They need, and they're getting it, and that's important. So I want you to be, and anybody who's listening, be assured that judges need protection. There are groups there that are standing ready and willing to protect the integrity of the judges, but I do believe that the security of the judges is another huge issue. It used to be that a judge would be in danger of maybe a party that didn't like, somebody that was part of the case that was before them, and usually that happened in domestic relations court. Now it's people who are philosophically opposed to what the judge has done, or what the panel, appellate panel or the Supreme Court has ruled, and that is harder to identify and probably harder to protect a judge or justice.
There isn't a whole lot that sitting judges can do because of ethical restraints, right? But there's a whole lot that former judges can do, and that's why we're here. And then here's the bad news. There's a lot that you can do, but here's where it gets really bad news, okay? You've got to understand how the courts work. And you don't, I'm afraid you don't get that just by reading newspaper accounts or social media accounts. Here's the really bad news. You got to read what the court does. And that takes a lot of work, and who's got time to do that? But when you do, Justice Barrett says this. She says, people say we're partisans and hacks. What do I say to that? I say, read our opinions. Because if you read the opinions, you will see that what's going on here is not partisan politics. What's going on here are people struggling with difficult legal issues, trying to get the right answer. And you and everyone else needs to understand that's what's going on. So that when you hear somebody use the phrase like judicial coup or judicial insurrection, you can say, that's not what's going on. Here's what's going on. And fill them in. If you just rely on social media, you just rely on cable, either side, you just rely on the media, I'm sorry. They've bought into this idea that it's just partisanship in robes, and they're wrong, and it's damaging. And you and we need to be the ones to show them what's really going on with the judiciary right now.
And I was really impressed with Justice Roberts, who recently went out and said that there's a lot of misidentification and description of what's going on in the courts, and he said it. We've got to stop that. So that's an opportunity to speak out by the Chief Justice.
And if you want to get like the very basics and from the inception by our founding fathers, Federalist 78, written by Alexander Hamilton, take a look at it. It's an easy read, but it really lays out, for our purposes and as an initial intro, the role of the judiciary as envisioned by our forefathers.
I want to leave a few minutes for a couple questions at the end, so I want to end on maybe a hopeful note. We've talked a lot about some attacks on the judiciary and the rule of law, particularly over the past year, but what gives you confidence that those guardrails are holding firm? What gives you confidence that the rule of law will endure over the next 250 years?
Well, I would start off by saying I do a lot of speaking to young people, to students, to groups. I still teach a course at a law school. I'm scheduled, if the weather permits me, to go to Dickinson's School of Law in Pennsylvania in Carlisle on Tuesday, and I'm going on Judges Night, and I'm going to have an opportunity to tell those students that you need to protect the rule of law. And in the future, it's your generation that has to make sure that the rule continues on. So I have confidence that young people in the next generation are going to protect all that's associated with the rule of law, and I like that.
We have 9 people on the Supreme Court who are acting in good faith, trying to keep their oath. I disagree with some of their decisions, but I don't question the good faith of any of them. And so therefore, that's my hope. I think the Roberts Court is going to point the way for how to preserve the rule of law at a time when it's under a great stress test, because we have an executive branch that doesn't respect the rule of law. the Roberts Court does, I think they'll pull it out for us.
We've had unprecedented attacks on the rule of law ever since 2016. I remember in 2018, I was being interviewed, and I, criticized the then president about his attacks on the judiciary, and that permission, when it comes from on high, emboldens people to attack the judiciary, and also thereby the product of the judiciary, which are, interpretations of our statutes. Do I believe that the rule of law will prevail ultimately? Absolutely. This is a blip, what we're going through. I think our institutions, by design, are strong enough to withhold and will be repaired at some point. They will be repaired. We will return and maybe be better for it. I don't know. But I also want to emphasize that I think this is the buzz of the media at this point, and they like to write about the sky falling and everything else. And yes, there are some very severe repercussions of what's going on. People are dying and people's rights are being trampled. But I think ultimately the rule of law, just like we saw in the latest Supreme Court opinion, the rule of law will prevail.
Thank you all. I think we have time probably for one or two quick questions. Good, we have a microphone. We have a lot of questions. You want to go right here to the front?
Hi. You spoke about reading the opinions to understand the court. Lots of things happening on the shadow docket. We don't get to read opinions or know their rationale. Can you speak to that, please?
Sure, I'd be happy to. So the shadow docket's actually the emergency docket, the interim docket, shadow docket. Will Bode came up with that cute phrase. And no, this is new, right? This court has never been inundated. The court has never been inundated with the number of emergency appeals that they have right now, and they're struggling with it. Sometimes they get it right. Sometimes they don't. But here's the key: we're in the third inning, right? We're in the third inning. We've only had a couple of cases, and the emergency docket is largely dealing with jurisdictional issues, procedural issues. They're not dealing with the ultimate merits issues. I'm going to make a prediction. I'll bet you a steak dinner on it. Okay, I won't bet a house payment on this, but I'll bet you a steak dinner on it. After you see the merits decisions by the end of this year, I think you'll say, okay, they're doing their job. They're doing their job. Now, the president's going to win some of these cases because he may be right on some of these cases. He's going to lose other of these cases because he's wrong on some of them. It's going to be a mixed bag. It's going to be a mixed bag. But I'm confident that they're going to come out all right.
I agree with you on your last statement there. In the meantime, damage is being done. And if I were ruling on an emergency and there was an injunction that the question was, am I going to sustain the injunction or am I going to lift it? And it was demonstrated that there was going to be harm. Okay, I would probably rule opposite in the emergency. I would maintain the status quo.
And we would disagree on that because that's what they've been doing. That's what they've been doing.
Let's have our next question right here.
Hi. In 2024, the Supreme Court ruled that the president can't be prosecuted.
Right.
And that shocked and amazed many Americans. And I asked Judge Ludwig what he thought about
Actually,
that.
Ludig.
And Ludig.
Yeah.
Okay. And he said, yeah, okay, that was not only an outrageous attack on the rule of law in the United States, but on the very concept of the rule of law going all the way back to Magna Carta. Okay. So how can you say that the Roberts Court is a defender of the rule of law when they destroyed it in the United States?
So I corrected you on his name because Mike Ludig is one of my closest personal friends. We communicate with each other every week. We went to law school together. We served in the ABA Task Force for American Democracy. He co-authored with me Lost, Not Stolen, the conservative case that Biden won and Trump lost the 2020 election. So we are We are joined at the hip in many ways. I don't agree with everything in the immunity decision, but I don't agree with his assessment of it. They were following. We can get into a long discussion about this. It's a tough issue. It's a difficult issue. People, should we? The greatest beneficiary of that decision was President Joe Biden. Oh yeah, no, absolutely, because he can't be prosecuted by an executive who would otherwise exist. So do you agree with the Fitzgerald decision upon which it was based? No. Answer my question. Well, then wait a second. Then you shouldn't be talking about this. This is based on the.
All right. I don't think we need to really defend, or you have your opinion about the case, and I would tend to agree that I think it was wrongly decided. I thought it was awfully, but I'll give you another one. Citizens United, the introduction of dark money into politics, and I think that hits at the very core of transparency in our elections, identification of messaging. The people have the right to know and not be deceived.
And I this is a great question that he has raised, and I'll try not to get into politics. I'll try to respect the courts. They have difficult jobs. Let me remind all of us that President Richard Nixon didn't want to turn over the tapes, and he was talking about executive privilege, and what happened is that the court said you didn't have it. No one is above the law. So I certainly understand, that position, but the key is that we've got to defer and respect the opinion of the Supreme Court in whatever decision they make, because again, they made a decision based on a lot of review and consternation and so forth. So that's the key for me, is to respect the ultimate decision, because that's judicial independence, and that's what the rule of law is about, respecting our courts.
And I'd be happy afterwards, we're running out of time, I'd be more than happy to talk to you about the immunity decision. I'm not completely sanguine with it, but I don't agree with Mike in terms of what motivated it and the damage it will do. I'm not happy with it, but can we? I'd love to talk to you about it further, but this isn't the setting or the time to do it. And anyone else who wants to talk, I'd be happy to talk about the immunity decision.
Thank you. I know, I think everyone has really enjoyed this discussion, and I'm sorry it's coming to an end and we don't have more time for questions. But I really appreciated the three of you being here and espousing your views, and thank you so much.
Thank you.